Okay, let me call the matter for the record. This is cause number 1154. This is in the estate of Edward Chris Smith, sitting in the county court of Jim Hock County. Let me have announcements for the record, please, from Counsel of Record.
Yes, good morning, Your Honor. Orlando Garcia here on behalf of Plaintiff Samantha Smith.
Amanda Torres on behalf of the defendant and independent executor, Joseph Richard Rick Rod.
Okay. Ms. Torres, I know that you have a motion to compel discovery. Do you have any other pending motions that are seeking affirmative relief?
Your Honor, I have a motion pending, but it's not set for today. And I was derelict in getting it set for this hearing as well, but there's one pending that's not scheduled for today.
That's pending and has been filed?
It's been filed. It's a motion to exclude late designated witnesses, but I did not get it set for this hearing. I just did not do that. So it's pending, but not set.
Well, I was a little confused about an assertion in your pleading that you had filed certain things that I wasn't aware of. So I said any other pending matters.
Okay.
Are you ready?
Yes.
Are you ready to proceed on that motion?
Yes, Your Honor.
Mr. Garcia, are you ready on that?
Just to clarify, what motions are pending? I mean, I know we have a motion to exclude Clay Hoblet.
That's it.
Motion to exclude Clay Hoblet and a motion to disqualify Clay Hoblet, right?
Yes. If you'll give me 1 second, I just need to pull it up because I think it's been some time since it was filed.
Okay.
And
I wasn't aware of that motion, so I never saw it. That I know, I was never aware of it, but it was referenced in your motion. So in an abundance of caution, I set all pending matters for hearing.
well, I mean, and that's fine. We can proceed. I mean, I think that
It's your
I'm
motion.
ready to argue it. I don't know if Mr. Garcia is or has an objection to that, but I didn't set it for this hearing. So I mean, I will represent that. That's the truth.
It's your motion. You can pass it or agree to. I don't know. I was aware that you asserted that it had been filed. I was not aware of it. And rather than this be a clerical issue, I broadened the order setting the hearing date to include all pending matters. Is it in fact filed? I guess that could be crucial.
It is filed, Your Honor.
I'm surprised. Did you send me a copy or did your office send me a copy?
I'm trying to, let me see about that. This has gotten hold on. So the motion itself was filed on January 26, 2021. And it's our motion to exclude late designated witness, motion to disqualify late designated witness from serving as counsel to Kathy Sugarick, and in the alternative, motion for leave to conduct discovery. I don't know that we sent it to Your Honor because we normally send you the documents as they're set for hearing. So I can't represent that it went to you, at least not right now. I can find out while we're having this hearing, but I don't know that I sent it to you individually, Your Honor.
Mr. Garcia, what's your view of this?
Yeah, I am. I'm going through my pleadings here to see when this was filed. I was not aware that this hearing had been expanded to include pending motions. I just generally recall the motions, and I'm trying to find them.
I think you filed a response, Orlando.
Did I? I know I filed a response to the motion to exclude you filed a motion to exclude Bill Barfield, Joe,
oh, that's the one I was
Kathy.
thinking of. Sorry. Yeah, no.
And then
Um,
subsequent to that, we designated Clay Hoblet. And I know that resulted in 2 more motions. And I don't believe that I've responded to those.
So the only pending motion that I have besides the motion to compel, which you did file a response to yesterday or today, I can't remember, is this motion to exclude late designated witnesses, and it's concerning Mr. Hoblet. That one I do not see that you filed a response to.
No, I know I did not.
And I mean, I'm prepared to argue them both. They are kind of interrelated, or we can, I don't know if whatever the court wants to do.
Judge,
I'm not sure.
I'm just not prepared for those motions today. I don't think either one of us knew that those were going to be the subject of today's hearing. And to be quite frank, I cannot locate. When did you say they were filed, Amanda?
January 26, 2021.
That would be, wow.
Ms. Morales, do you have it filed in your official court records, January 26, 21?
Let me check on that. It's because I just took over for the girl that's absent today. So let me check on the.
Okay, I'm sorry. I'm calling you Ms. Morales. What is your name?
I'm the assistant, Ray Gutierrez.
Ray Gutierrez. Okay, Ms.
Yes.
Gutierrez. Okay. I'm sorry.
It's okay.
For instance, your proposed order that you filed, Ms. Torres, the Jim County's clerk sent me a copy of your proposed order yesterday, and then I got one from you today. So the clerk has also been real good about sending me copies of filed matters. So it might help if Ms. Gutierrez was able to establish one way or the other that was actually filed.
I'm having my paralegal send it to you right now, Your Honor, to your email while that's happening. And also to you, Mr. Garcia.
Thank you.
Well, I hate to not deal with it. It's so cumbersome to set up hearings, but Mr. Garcia, if you're not ready, you're saying you're not ready, I guess we'll just have to pass it. But I would like to know if it was filed or not.
And what exactly are you looking for to see what was
I'm
filed?
looking for something that would have been filed on January 26, 2021, thereabouts in those days, having to do with
Is it the defendant's Rod motion to exclude plaintiff's late designated witness, motion to disqualify
Yes.
witness? Okay, yes, it was filed on January 26, 2021.
okay. Well, Ms. Torres, I apologize. I was never made aware of that pending matter.
That's okay, Your Honor. I don't know if how soon we can get another hearing on that issue. So it's up to you.
It's a real tough. Mr. Hernandez has to go through a lot of. He serves several counties and
Your Honor, would
pretty
it be
much got to get permission from those judges or that judge to set up a little time for us. So this is.
well, would it be possible to maybe recess for about 30 minutes or so Mr. Garcia could review that motion again, and then maybe we could then argue it at the end of this hearing, since it is a little difficult to get hearing dates and we're trying to get a DCC set for trial.
Well, what kind of trial dates are we looking at? I mean, if we're looking at another, well, it's been a year, but another, several months. I would like to be able to file a written response. I mean, I understand it's cumbersome, but if we have time, I would have to suggest, and this for the sake of my client, that I get that time. If
Okay,
it's-
well, let's discuss that, the issue of the DCC. Ms. Gutierrez, are you going to monitor the whole hearing, or are you just here to help us with the DCC? The docket control conference. Can you hear me? I'm sorry. Ms. Gutierrez?
Yes, sir.
Yes, ma'am. Are you going to monitor the whole proceeding, the whole hearing, or are you here just to help us with the docket control conference?
I'm just here to see what's gonna happen next. The court reporter, Mr. Hernandez, is the one that's taking over everything, documenting everything, but I'm just here in place for Kathy to see if y'all need anything from the file or what has been filed.
Okay, well, when I said the docket control conference,
Mhm.
it was kind of before this new variant kind of blew up on us again.
Yes.
I don't know that we're gonna have a trial setting anytime soon, to be honest with you. I mean, we went
Like
from
on our
7
district court, we're still having trials, but we're having them in another building. Like we have one on August 23rd, but we're having them like in a pavilion area, like a bigger area where they already planned out how to do everything. So we are still having trials.
jury trials.
Yes.
Okay, well, that's positive.
We just got one set in Stark County, and I mean,
Yes, because we deal with Stark County also.
yeah, and that's why I've seen Mr. Hernandez this morning. But since I was set to go to trial next week, and we had a status conference in light of the numbers going up. We don't know if it's going to be a quick spike or something that's going to be more ongoing. We set it to October, late October, but they are holding, or they do have an operating plan in place for the Stark County, Jim Hogg County region.
Yes. Just
And
like
you
here.
You had actually have had jury trials in Jim Hogg County.
Our first one is going to be on August 23rd.
Okay, well, that's a curiosity, because I wonder if you're gonna be able to do it and have no one get sick, and make sure that no one gets sick.
Yes.
That's the big test.
Yes.
I don't want to be responsible for anyone.
We already called the jury. We're about to send out all the letters and stuff. And the judge says he's still going to go forward with it.
Okay. From a personal standpoint, do you know what the judge is doing to protect himself or herself? I'm as worried about myself as
Yes. Yes. As of now, it's a bigger place, and he just, I guess, has the mask. He has his own plan. So I don't know. See how it goes. It's gonna be our first one.
See, here's the thing. I mean, I don't want to jeopardize anybody's health.
Yes.
Not my own.
Yes.
Unless we do set it for trial, this thing is never going to get resolved. And it's the ultimate leverage that the trial court has to have this thing come to an end. So it's a very delicate balance. What are your thoughts, Ms. Torres?
Yes, Your Honor, I totally agree that we need a trial schedule to help us move this towards some finality. I would suggest, I mean, just based on our own personal schedules, trial schedules, that if we set this for trial, that it be next year in February. That might give some time for this Delta variant to subside and, for things to shake out with that. That's just based on our own trial schedules. We have trials pretty much every month except towards the end of the year.
That's actually, I mean, that's in line with my trial schedule, because I have an arbitration. I have late October, then an arbitration, and then a November pretty complex mediation. It shouldn't interfere, and then my next trial is in in April, so February is perfect.
Okay, let me do this. Let me just calendar after August 23rd. I'll call the clerk's office in Jim Hart County and get an update on how their plans worked out, whether they were able to have a trial and everybody was able to get through their job and no one got sick and everything's okay. I think you kind of both agree in February. That's okay. I mean, it could, that could be, that seems very workable. If I was just reading today that in England, the numbers have started to subside.
Right,
So we may be 1 or 2 or 3 weeks behind England in terms of the curve.
right.
Uh,
And the vaccination rates are going up too, I think. So, I mean, by that time, we may see the numbers level out again.
So let me calendar, I'm gonna check with Jim Hong County. I'm not gonna issue a docket control conference, but I know that you all are looking at February 22nd, 2022. And if they have success with this one, then that'll be a green light. If not, I'll just have to rethink it. If they go to trial and it works out and the numbers start to come down like in England, then I might do a docket control order. I'm not gonna, I gotta work this out with Mr. Hernandez. He can give me a week. I'm not gonna give you a chance to participate in a conference as traditional DCC. I'll set up a date and then you all are either, you kind of go with it or file a motion for continuance.
And this is for February 22nd, Judge?
Well, that's what I'm considering. I'm not
Okay.
issuing an
Awesome.
order.
Right.
I mean, you're both, your schedules seem to be coinciding in that regard, and that's good. I don't want to deal with it before then. And there's no, I'm not in any hurry before then, so that's okay with me. So in light of, Mr. Garcia, you were wondering about what kind of trial date were you talking about with regard to whether I should proceed on this motion
Mm-hmm.
to,
Yeah. So, that's 6 months. That's exactly what I thought. I would like to have that time to file a written response to those pending motions.
is this understanding what the facts and so forth, or is this anything that I could do by submission?
You could do this by submission, Your Honor. I mean, I think so. I don't think that there's not going to, at least on our end, I don't know about Mr. Garcia. We don't have live witnesses or anything other testimony to offer you other than what's already been admitted or offered as an exhibit to each motion.
Mr. Garcia, do you agree or disagree?
No, I agree with that. I don't have a problem with this being by submission. It's probably, yeah, I don't object to that.
They're kind of related, Your Honor, in the sense that we obviously want to exclude Mr. Hoblet, who we feel was late designated. And he's also wanting to serve as counsel to one of their other witnesses. Her name is Kathy Sugarick. And we don't think that's appropriate. So that's in our motion. And then also in the alternative, we'd like to conduct discovery. We believe the discovery period is closed, so we would not be able to do that without permission. And then and then we have this motion to compel information from the plaintiff on certain production requests. And so they're kind of all related in the sense that we really need to kind of firm up or figure out whether discovery has closed or not and what we can do going forward. So I'm okay with you hearing both of these on submission if you'd rather do it that way, or if you want to go ahead and continue with the motion to compel, we can do that. But the motion to exclude, I'm okay with that one if you'd like to hear that on submission.
Okay, I'm going to hear the motion to compel that you filed, that everyone is aware of what's said, and I want to have that hearing right now.
Okay.
I'm not going to issue a docket control order. I'm going to wait till August 23rd, see how this trial goes for Jim Hart County. I'm afraid that they're going to subpoena with jurors and nobody's going to show up. So I kind of want to see what happens. And on the other motion, you've indicated, Ms. Toda, you're gonna send it to me. I'll
I just
consider it.
did. It just went out, so hopefully you
I'll
got it.
consider it by submission, and Mr. Garcia, I'll give you, how much time do you need to file a response to that?
Well, next week just opened up, so if I may just have, I do have, towards the end of next week, if I can have next week to do it.
Fine with that.
Sound
yeah.
like within 10 days?
Yeah. Oh, yes, Judge.
Within 10
Yes.
days. Okay, I'll give you 10 days to file a response. And if I feel comfortable ruling on it by submission, I'll issue an order. If not, I'll set it for hearing.
Very well.
Okay, so Ms. Torres, I'll hear you on your motion. Proceed.
Thank you, Your Honor. This is a motion to compel the production of certain documents. I'm sure the court is familiar with this case, but since it's been some time, I'm just going to give a very brief background on what this case is about. I'm sure, unless you want me to move on, but basically we have our client who is the executor of the estate of Edward Chris Smith, I'm sorry. And he was a friend to the decedent, and he was he had a lease to hunt on his land. They became good friends. The decedent had a medical condition that required him to be hospitalized. He needed heart treatment. He suffered a heart attack. And my client, along with some of the decedent's family members, were there and provided care and friendship to the decedent while he was in the hospital. While he was in the hospital, he signed a holographic will, leaving his ranch to my client, which is a subject property at issue in this case. The plaintiff is the decedent's estranged daughter. They did not have a relationship for a long time, many years, and she has brought suit to set aside the holographic will. And so that's the nuts and bolts of the case. Obviously, the plaintiff has a different view of how that will came to be than we do. That's an argument obviously we'll make to the jury at the right time. But we're here today because of the production request that we have submitted. This plaintiff has stated that she has no personal knowledge of any of the events that transpired around the signing of the holographic will, or events before or after it. She said that she's basically just been told things by other people. So we are seeking information related to exactly that. What does she know? What has she been told? What is she basing her claims and allegations on? We submitted a request for production, and we call it number 12, and it was sent in our first written production to the plaintiff. This court already ruled on that and sustained the plaintiff's objection as to attorney-client privilege and ordered them to basically produce a privilege log to any other documents they chose to withhold, but otherwise to produce documents. The plaintiff's response in her response to that request for production was only one objection as to attorney-client privilege, and then subject to that, none. The request itself was for any written and electronic documents plaintiff or anyone on her behalf exchanged with third parties regarding the decedent since September 1st, 2017. So plaintiff's position is that there are none, so they have no duty to supplement anything. And that's what the response has been in a letter response, which is fine. But we then sent a separate RFP, we call it number 21. And in this response, we requested written and electronic documents, texts, emails exchanged with any third party since September 1st, 2017, regarding the decedent, the defendant, the estate of the decedent, and your claims and causes of action. So this request is very similar to our RFP 12, number 12, except now we have broadened it from, or narrowed it, depending on how you read it, from documents, just asking for documents, to asking for documents, text messages, emails, exchanged. So we've gotten more specific. To this request, 4 objections were submitted. Not relevant. Number 1, not relevant. Number 2, overbroad. Number 3, failure to comply with Rule 196.4 and tell plaintiff how he wanted the electronic information produced, and attorney-client privilege. And then, subject to all of those 4 objections, the response was none. So taking up each of their objections on their own to RFP 21 is important, because if there are any documents, text messages, or emails, then that affects RFP 12. RFP 12 already says none. So if that's the case, then we know at least there are no documents. But what about text messages and emails? If there are some, then we have to address these objections. They say it's not relevant. Well, obviously, any text messages, emails, or exchange with any third party by the plaintiff or on her behalf are relevant to these claims and causes of action that she's bringing, because she herself has said she has no personal knowledge of anything in her petition. It's all information based on what other people have told her. So we need to know who has told her. We are seeking this information because once we get to trial, we have the right to cross-examine. And we have the right to cross-examine based on the documents and evidence produced. And so we need to have this information. It's obviously relevant, and it is going to relate to information that will be admissible in trial. And it's reasonably calculated to lead to that discovery of admissible evidence. So that objection we feel fails. The next objection is that it's overbroad. But this request, RFP 21, is narrowed as to time. It has a subject matter. It's narrowed as to the documents and items requested. It is not overbroad in any sense of that word. Documents, text messages, emails exchanged with any third party since September 1st, 2017, regarding the decedent, defendant, estate, and your claims and causes of action. So there's no overbreadth there. And besides, according to them on request for production number 12, there are no documents. So that should be easy to just wipe out. So really all we're dealing with is text and emails. Do they exist or not? It's not overbroad. The next thing is they say we failed to comply with Rule 196.4 because we did not tell them how to produce the electronic information. And this is an objection that they make to all of our requests. So it spans all of the RFPs 13 through 21 has that same objection. They all have these same objections. And that is not something that they can just say, oh, well, you didn't tell us how to produce it, so we're not going to produce anything. They have an obligation under the rules to produce information. And the federal rules say that if we don't tell you how to produce it, i.e., USB, native, or some other form, that you still have to produce it in any reasonable fashion. So they can choose to produce it in native form, or they can choose to produce it in a reasonable way, but they have to produce something. They can't just say, we're not going to produce anything. And so we think that that objection fails as well. The last one is attorney-client privilege that they assert. And again, they have not produced a privilege log. So if there is an attorney-client privilege, they need to submit a privilege log so that we can then see what is being withheld. We already know that under RFP 12, request for documents exchanged with any third parties, it was said that there are no documents. And the only objection asserted was the attorney-client privilege. And this, I want to emphasize here, the request is for the plaintiff and anyone on her behalf. Obviously, her attorneys are privileged. That's a privileged communication. But if somebody else is acting on her behalf and communicating with her attorney, that is not a privileged communication unless there is an attorney-client relationship with that person. So we know that there are communications happening with, for example, Robert Smith, her uncle. His deposition testimony was that he never talked to her prior to this incident, the heart attack incident with his brother, her father. But since this lawsuit began, they've been talking every week. That's in his deposition testimony. So we're entitled to this information. It's there. We know it's there. And in his case, we know it's particularly relevant because he testified in his deposition that before the lawsuit was filed, Samantha Smith, plaintiff, and himself, Robert Smith, had come to some kind of verbal agreement or verbal discussion about her bringing this lawsuit on his behalf and then conveying the property to him in exchange for him paying her attorney's fees. And that was in his deposition testimony. So this information, it is relevant. It is likely to lead to more admissible evidence, and we're entitled to it. So as to RFP 12, maybe the answer is none. Maybe there are no documents. But if there are emails and text messages to RFP 21, then those need to be produced. And anything that is being withheld on privilege should be subject to a privilege log. So RFPs 13 through 21 are all the same. These are specific requests for information exchanged with targeted witnesses. For example, there's the decedent, RFP 13, Sandra Varial, RFP 14, Robert Smith, RFP 15, Araceli Smith, RFP 16, Aaron Varial, the plaintiff's brother, who called her to let her know where her father was in the hospital, RFP 17, Rolando Spider Varial, RFP 18, Alma Carpenter, I'm not sure if I said that last name right, RFP 19, Carlos Gallardo, RFP 20, and any third party RFP 21, which we just discussed. Those are exactly the same, they just have different people. And their objections are all exactly the same: relevance, overbreadth, and failure to comply with 196.4. And for the reasons I've already discussed, I feel that those objections fail. So we know that Robert Smith testified in his deposition on January 10th, 2020, testified that he might have some text messages with her on his phone, but that they did have text messages. And we're entitled to those text messages because they are relevant and likely to lead to admissible evidence. And they discussed an agreement, a possible disagreement of conveyance of the land to him in exchange for payment to her. So we want that information, Your Honor, and we think we're entitled to have that information in preparation for the trial. In RFP 22 and 23 deal with cell phone records. RFP 22, we ask for all cell phone statements for your cell phone, and we provide the number 361-701-4854 since September 1st, 2017. In RFP 23, we ask for all cell phones for any phone you used. Now, the reason we had to request that particular RFP is because, if the court will recall, the plaintiff allowed her child to play with her phone and delete all of the text messages in order to make room for some kind of game. So we know that at least 2 phones were used, the original phone and then whatever phone she used after that. But we don't know which phone that is. And so we've asked for all of her all cell phone statements. The response was objections as to relevance, overbreadth, undue burden, and that the expense of such an endeavor outweighs the benefit. Well, I have to disagree that the expense outweighs the benefit, because these are cell phone statements that the plaintiff can easily get from her carrier. They've already provided certain statements. For example, they produced statements for the period of August 28th, 2017 to February 27th, 2018. But that date where they just cut it off arbitrarily is before they filed their lawsuit. So I don't know why they cut it off at that date. They provided no cell phone statements for after that date. And here we are in 2021. So while their position might be that, the daughter deleted all these text messages, so there's nothing there, we're still entitled to the cell phone records so that we can see the dates the text messages came in, the phone calls going out, because Robert testified he's talking to her every week. And since her daughter deleted the phone and she got a new phone, all those text messages should be preserved. So if there's anything there, and if there's not, the answer is none. If there's anything there, it should be produced. It's not an undue burden. The plaintiff's response provides no evidence as to how this is an undue burden, and any party resisting discovery carries the burden of showing why discovery should be withheld or resisted. There's no evidence of undue burden. There's no evidence of a disproportionate cost or expense. No evidence of that. They also say that it's vague, at least to RFP 23, that any phone you used is vague. Well, we don't know which phones she used. She's the only one that knows that. So she needs to provide the cell phone statements that she used. And again, they did provide cell phone statements, but only for a short period of time. So that's already, they've already identified the phones. They just need to give us the rest of the time period after February 27th, 2018 to the present. So that's the request that we're seeking. That's the information that we're seeking. And I'm happy to take up any of these individually or allow Mr. Garcia to respond in full. But basically, we're seeking information, Your Honor, related to the presentation of this case. And the answers are either none or here, see documents produced. And we just would like to know if there are in fact none, the answer is none.
Does that conclude your presentation, Mr.
Yes, Your Honor.
Response?
Yes, Judge, thank you. Judge, in my response, I went probably a little further and in more detail than I normally would have about our position on the facts of the case, the period of relevance, if you will, which is the period of time in which the decedent found himself in the hospital. And of course, his condition beforehand is relevant to contrast his mental state for the jury. So, some period of time before September 24th, 2017, when he was admitted into Cristo Spawn, and then he was there for about 5 months, 30 days into his admittance, after he had experienced 7 cardiac arrests that resulted in him flatlining and almost dying, being in the ICU, going through a major bypass surgery, being on a ventilator. That all happened within a span of a couple weeks. Right after he gets out of that position, he's in a step-down unit. He's surrounded by the defendant's friends, a relative of his who developed a relationship with the defendant. He gets this document to copy. That document becomes the holographic will in question that we're contesting, okay? His mental state at that time is in question. We're saying he lacked testamentary capacity. They're saying he was of sound mind. We're saying there was undue influence exerted upon him prior to him executing that written document. They're saying there was no such undue influence. My client conceded in her deposition that she had not spoken with her father in quite some time. I believe it was almost 2 years. She lived in San Antonio and had a new life going. He lived in Heavenville on the ranch. He never left that ranch. Their parents divorced. They divorced. The parents divorced. Mr. Smith, Edward, and his ex Sandra divorced in 2014. After that, him and my client didn't communicate very much. We've conceded to that. She testified to that. She nonetheless has standing to bring this suit. She can do it even though she doesn't have personal knowledge, right? She did it. We did it on information and belief, which opened up the ability to conduct an investigation. And that's how we know what we know now. Now, we had to list persons with knowledge of relevant facts. Some of those people are going to be our trial witnesses. They had the ability, some of those we late designated according to the defendants, but we never objected to them taking the deposition. As a matter of fact, I don't concede that the discovery period is closed. I believe there's a long line of case law that says when there's a resetting like this, unless the court orders that everything be frozen, it's open. But nonetheless, I never argued with them about it. I said, you can depose all these people. You want to depose them? Let's depose them. Who was there? Who talked to him? Who spoke to the decedent? Those are the people with information. Now, what's interesting to me is Ms. Torres has gone through request 13 through 21, which seeks any emails or text messages that my client exchanged with members of her own family. And Ms. Torres has said, well, some members such as Robert Smith, the brother of the decedent, her uncle, admitted in the depot that they were talking every week. Of course they're talking every week. Of course they're talking every week. I mean, this has resulted in a big question mark in their lives because the man who is now in charge of the ranch, the main corpus of the estate, is a man that knew Mr. Smith for less than a year. Nobody really knew who the man was. So yes, big question mark. So they've communicated regularly. My issue with the request, Judge, for text messages and emails is simple. They're telling us, and they've in the motion, and they've repeated it here today, is that any such information is going to be hearsay. Well, if it's hearsay, then how is it going to ever be admissible evidence? And what relevance does it have to Mr. Smith's mental state on October 28, 2017? It has no dispositive value, no probative value to that question. And so I did object when they specified that they want my client's text messages with any third party about her father. I mean, just think about the breadth of that, Judge. Any third party that my client exchanged a text message with where she discussed her dad's death or the estate, I've got to produce that text message from 2017, from September 1st, 2017, all the way up to the present. He's been deceased for over 2 years.
Mhm.
And let's assume, just for argument's sake, that there is an agreement or was an agreement before the lawsuit was filed with my client and her uncle, where her uncle said, Sam, you need to file a lawsuit. You're the only one who can do it. Go do it. And then I'll pay your attorney's fees and you give me the ranch. Even assuming that's true, what probative value does that have to determine the testamentary capacity of Edward Smith? It doesn't have any. It has no relevance. So I keep harping on relevance because I think it's dispositive. I think it controls. I do think that they're overbroad because from 2017 to the present is absurd. And for any third party, for me to try I don't even know how I would begin to do that with my client, to say, I've got to get you to think about any third party you've exchanged a communication with about your dad and print that out for me. That, in light of the facts of the case, Your Honor, in light of the issues at stake in determining the outcome of this case, I don't believe that that's right. And so that's why I say they're not relevant, Judge. And as to the phone records, initially, we felt the same way. However, the phone records with my client did make a claim during the deposition that she had attempted to call the hospital when her father was admitted. And so, you know, at least during the course of his hospital stay, during the period of time in which he was in critical condition, when he copied that document, I felt, okay, well, they should at least be able to test the veracity of that statement if she did try and reach out to her dad while he was in the hospital. So I produced from the month beginning when he was in the hospital, actually the end of the month that preceded when he was admitted, to the end of the month in which he passed away. And I produced those phone records to them in full. But what they're saying is I arbitrarily cut off the date. Well, no. When they produced phone records to me, they cut off the date at some point in time, and it was before the lawsuit was filed as well. They're saying that they produced other text messages after that time, but they're not discernible. And they're saying it's because of the program of the phone. It was an old phone. It doesn't matter. The point is, I haven't made a big deal about it because in my mind, the most important, well, the relevant period of time is when Mr. Smith was laid up in the hospital interacting with the defendant, a family member, whoever visited him, that we know of. And I don't know if you recall, Judge, from the last hearing that we had in January of last year, but the defendant has had possession of Mr. Smith's cell phone. So anybody that made a call to his cell phone, anybody that sent a text to his cell phone, we have all those text messages. We've all read them. We know who he was communicating with. We know who called him. Now, what they want is they want communications between the family members that none of whom were there. Why? What admissible evidence is that going to lead to if it's already conceded that it will be hearsay? On top of the hearsay, what relevance will it have to determine the capacity or the undue influence that may have been affected on Mr. Smith? And that's been my position. I've briefed it to opposing counsel in letters extensively, and I stand firm to it because it's going to be extremely burdensome for me to go and find every email and text message to a third party that my client sent about her dad. And what relevance will those have? You know, none. She wasn't there in the hospital. She wasn't there. So I believe it's a fishing expedition, Judge. I think Ms. Torres said it plainly herself. If there's anything there, then produce. It's not that simple. If there's anything there, it's not. We don't just say none or we're going to produce it. There are other mechanisms in place, such as whether it's relevant. Judge, I disagree with its relevance, and I understand opposing counsel's position, but
Rosie call 702.
But we disagree given the claims in the case. And remember, so he was admitted September 24th, 2017. He signed, he hand wrote out that document that he copied from another document on October 28th, 2017. He was still in the hospital. He got discharged for some time in early 2018. He went back into the hospital after he got into critical condition. He died February 12th, 2018. And I've conducted discovery on that time period, all of the medical records. We took depositions of individuals who visited him during that time period, who had personal knowledge of his condition. Everybody who's had personal knowledge of his condition, who we have designated as witnesses, they have had the ability to depose. And so, Judge, I don't see how my client's text messages with her uncle or her mother or two of her uncles or her mother or her husband. Carlos Gallardo is her husband. Carlos Gallardo never had any contact with the decedent. Nobody has ever said that he did. As a matter of fact, he's not even a witness. So, you know, I respectfully disagree with opposing counsel, Judge. We don't feel that those requests are relevant. We didn't feel that way in January 6th in the last hearing. We still don't feel that way.
I have a brief response, Your Honor.
Sure, go ahead.
Mr. Garcia is trying to limit the period in question in this case to the period of when Mr. Smith was admitted to the hospital and the day he signed the holographic will, and that's it. He doesn't think anything else is relevant. However, he mentioned here at the end that Mr. Smith died in the following year, in February of the following year. Mr. Smith was alive. The will had been in place. His family members, Robert Smith and one of them, had been visiting with him. His friends had been texting him. All of this is relevant because Mr. Smith had adequate opportunity to change his will if he wanted to, but he didn't. This time period is relevant all the way to the present because we get to question witnesses. We get to cross-examine witnesses. Now he says it's all going to be hearsay, so it's not relevant. Well, Your Honor, we don't even know what they're going to say. So for him to say it's all hearsay is kind of strange. I guess he's determining that he's the judge in on that question as well, but you are. So you will be the one who hears what they say and determines if it is hearsay or not. But we are still entitled to any information likely to lead to admissible evidence. And we at this time know that Mr. Smith, and at least Mr. Smith, let's talk about him, because he said, well, it's her uncle. Of course she's talking to him. They had no relationship since 2014. And he testified in his deposition, he didn't talk to her since 2014 until this lawsuit was filed. And since then, they've talked every week. Now, that's kind of strange to have no relationship, and then suddenly a lawsuit gets filed and you're talking every week. Now, maybe because they're family and all of that, and that's fine. But we are still entitled to know what communications they're having about the estate, about the decedent, about my client, about their claims. And so to say that it's not relevant because it's not going to lead to admissible evidence, it's not related to the testamentary capacity of Edward Smith in October of 2017. Well, it is relevant to impeachment, to bias, to prejudice, to motive. It is relevant to know what these people are all working towards, which is recovery of the land and give it to her uncle. So anything he offers, any testimony he offers, is going to be potentially tainted by that settlement agreement, that motive, that relationship they have to this land, because he's offering testimony that says, you know, my brother never would have done this, never would have did it. He had to have been taken advantage of. He didn't know what he was doing. He wasn't in his right mind, whatever he's going to say on the stand. But we are entitled to know what communications they're having, what's motivating him to suddenly be friends with his niece, who he hasn't talked to since 2014. Same thing with all of these other people. We don't know what they're going to say. So Aaron Vidal, he's in prison. We can't, Mr. Garcia chose not to depose him. So we don't know what he's going to say. We don't even know if he's going to be called as a witness. The uncle, same thing. They say, oh, he was the decedent's best friend. Well, what's he going to say? I was his best friend. And I know that he would never have given the property to a stranger. Okay. Are there communications about that? It's yes or no, but it is relevant because it will lead to possibly, maybe, I don't know. I haven't seen anything. I don't even know what they have till admissible evidence. Now, for him to say that it's unduly burdensome for me, it's going to be so hard for me to get my client to think about whether or not there are communications with third parties. I don't know why it's so hard for him to get his client to think. I mean, she's not a moron, I don't think. I mean, she seemed very intelligent to me, but he can ask her to look and she can look. We are not requesting that she do some algebra or geometry. We're just requesting the communications. Now he goes on to say that it's unduly burdensome for him to examine these text messages, but he's offered you no evidence to support that, just his own testimony that for him, for counsel, it's too hard to do. It's unduly burdensome. He has the burden to meet when he's resisting discovery. He has offered you no evidence as to cost, as to time. He said, oh, Your Honor, she has 7 phones I have to go through. He has said nothing. He has given you no evidence. He doesn't even have an affidavit from his client of how hard this would be for her to do. He's just off telling you it's going to be too hard. I can't get her to think about it. I don't have time to deal with this. Or we have until February, if we get that trial in February. So there is time for him to produce these documents. Now he goes on to say that he hasn't made a big deal about us not giving him information about text messages because it's not a big deal because it's not relevant. Well, I can't control how he manages his case or what he's doing in terms of discovery, but we have provided him with text messages and we've even provided him with phones. And he has this information at his possession. So that argument is not before you, but it has been raised. And so I wanted to make sure.
Provided physically telephones or?
We provided him with our client's phone that he requested.
The actual phone?
Yes.
So
You to imply in a, okay.
the-
Go ahead,
the-
Mr. Torres.
it just,
Go ahead and finish, Mr. Torres.
So my response is that in closing here, Your Honor, I know you're gonna be the person to make the decision, but these communications with these people aren't relevant. They are not it's not overbroad. Any third party, an aunt, a cousin, a neighbor, yes, it's relevant. Is it admissible? That's a different question. Is it relevant to know what she's thinking, what she's doing, why she's doing this? Yes, it's relevant to her motive, to her bias, to what's going on. I mean, if there's a ton of communications, we don't know because no evidence has been offered about that. I don't know that it really is unduly burdensome. She hadn't had a relationship with him since 2014. So for them to say all of a sudden that now she's having a ton of communications about her dad or the estate or my client, well, that is interesting. And that is something that we would like to see. If there are no documents, Your Honor, there are no documents. We just need to have some certainty going forward into trial and knowing what is at issue here.
On the vehicle that you're asserting, the discovery vehicle that you're asserting, I compel responses to, they are requests for production.
Yes, Your Honor.
Does either side have any recent case law decisions that deal with the production of emails and text messages?
In what specifically?
You mentioned a rule, some text rule, and you mentioned some federal case law.
Oh, yes, Your Honor. I cited it in my motion. It is, well, Inree Weekly Homes is a Texas Supreme Court case that says that electronic information, requests for electronic information are to be clearly understood and disputes avoided. That discovery of electronic data involves case-specific considerations, and each side possesses unique access to that information concerning reasonable and viable production methods, resources, and needs. And then I cited an Inree State Farm Lloyd's 519 Southwest 3D 647 out of the Corpus Christi Court of Appeals that says that under the federal rules, when the requesting party does not specify the form for production of electronic data, the producing party is then offered a choice between producing the data in the form in which it is ordinarily maintained as a native format or producing the data in a reasonably usable form or forms. So that's in the footnote 7. So the plaintiff
when
has
they say none, why isn't that enough?
It might be enough. RFP 12 says there are no documents. RFP 21 is asking for documents, text messages, emails, and so is RFPs 13 through 22. I'm sorry, 13 through 21 ask for the
Okay, I had noticed. So the clarification is it none as to text messages and emails also?
Yes, that's all we want to know. Is it none?
Okay.
And if I may briefly respond, Judge.
Go ahead, Mr. Sesson.
I just want to clear something up.
By the way, before I forget, the deadline has expired.
Okay.
Now, if I'm wrong, I'm open to receiving argument. If there's case law that says it's expired, you may have motion for leave, whatever procedural vehicle there might be for either side to try to avoid injustice by seeking some sort of relief. But I start out with a baseline if it's expired. So go ahead. You were going to say something.
Okay. Yes, Judge, I just wanted to clarify. The cell phone that was produced to us, and I had received possession of the defendant's old cell phone. It's a flip phone. It's an old phone, analog old. The reason that we requested it was because of the fact that only text messages up to a certain point were available in a format that we could read. And it was the defendant's position that after that point, or before that point rather, he had a phone that you couldn't extract the data from. So I had the phone produced. I wanted to have somebody to look at it to see if there was anything from there, right? Because the defendant was in contact with the decedent. He was in contact with the other people who were there in the room the day when he signed the holographic will. He organized that entire event. So the text messages he sent at that time are relevant to determine Mr. Smith's mental capacity. I just want to remind the court that there's a difference between those communications with somebody who was admittedly there and in control of organizing this, what they claim was a will ceremony, versus my client who was in San Antonio talking to her mother or her husband, none of whom were ever there. Now,
So, Mr. Garcia, you're not comfortable providing an updated response that clearly responds
I am.
to text messages and emails. I want to avoid issues that really don't
Yeah.
substantively affect one way or the other, if I can. If you
Well,
want, if you're not comfortable for whatever reason, then I need to deal with it substantively.
Sure.
But
sure. So let me just say this with respect to the cases Mrs. Torres just went through, those federal cases, and that objection on 196.4 about the format in which they're to be produced. I will waive that objection. I agree that it doesn't preclude or it doesn't protect a party from producing stuff. So that objection was in there just because it does call on the other side to dictate the format if they so want. If not, fine. But as to the relevance objection, Judge, and the overbreadth, no, I will not. I'm not inclined to waive those objections. I stand by those objections because, Judge, even if my client, because we do know that my client's phone was handed down to her daughter. So at some point in time, she got a new phone. And of course, she's probably been communicating with her uncle. I'm sure she's been communicating with her father. And I don't think it's really out of the ordinary for her to do so after an event like this in her life.
Her father's
so-
dead, by the way.
Huh?
Her father's dead. I think you meant somebody else.
Oh, did I say her father?
Yeah, you did.
I'm sorry. Yeah, no, that's not through text messages.
That is something I want to know how she does, if that's true.
Right. Well, you have to tell me what format you want that in. No, she has most assuredly, Judge, been communicating with her mother, with her uncle, with her husband, and her family members since her dad's death. My concern is all of those text messages, to go and find every single text message to not just those people, but number 21 is like a catch-all to any third party about her father's death is just incredibly overbroad.
Well, Your Honor, what I would suggest here then is if he's going to say it's, number one, we're not looking for recipes, exchanging Pinterest pins or anything like that. Obviously, we're limited to the decedent, our client, the defendant, the estate, or claims and causes of action. Those are the 4 subject matters of text messages and emails that we want. But if he's saying the RFP to any third party is overbroad, then we would suggest limiting it to his trial witnesses.
okay, let me come back to this because I was hoping to have an easy out. But so on phone records, I think you described them as phone statements.
Yeah.
Ms. Douglas, that you were cut off. I'm thinking about my own phone statement. It's just a bill and I pay the amount that's due. The things that you did receive, did they have a transcript of phone calls and to and from? Like
No, Your Honor.
the old long distance listings we would get in our own phone?
They have the phone numbers, phone calls made to and from, and they have text messages received and sent along with SMS,
On
MMS.
phone records, you mean something other than the billing statement? Then you're talking about something else?
it's a bill, your bill statement shows your calls in and out and your text messages received and sent. And they already produced that to us for a certain time period ending in February of
You
20.
had those details in whatever you received.
Yeah, so we can see who's the calls coming in, we can see how long they last, we can see the day. And for the time period, at least where her phone was deleted, that's all the information we have at hand. We don't have access to actual text messages. And so that's the only important evidence that we have of those text messages or emails coming through is those statements.
So with regard to those phone record issue, it's the cutoff date? Is that the issue?
Well, yeah, because they provided records August 28th, 2017 to February 27th, 2018, which is the month that Mr. Smith passed away, but nothing after that. And nothing through the present. So we want records from March 1, 2018 until the present.
Okay, let me move on to the other thing I had a note here. Are you,
That's almost 3 years of phone records. That's
I'll let you respond to that in a minute, just
Okay.
With regard to the asserted agreement between the uncle and the plaintiff,
Yes, Your Honor.
have you formulated a theory, evidentiary theory that you conclude leads to its admissibility?
Well, Your Honor, we don't have any documents. So no, we have not yet been able to prepare that. Obviously, we're not ready for trial yet, but part of that obviously is that we need documentation. And that's why it's important to know whether there are no documents, no text messages, no emails. And if there are, then that
I'm talking about specifically the agreement that you elicited in a deposition.
all we have right now, Your Honor, is his deposition testimony. Obviously, the phone was deleted or destroyed or whatever evidence was on there at the time is gone. And then we have nothing after that.
And you have a theory that depending on what a document shows will make it admissible or non-admissible?
Well, we need yes, obviously any emails or text messages or communications about their agreement would show that number one, it does in fact exist, or what the terms are and what the understanding is between the two. And it would then obviously at that point be admissible through the custodian of that document, the custodian of that record.
Why do you think it's automatically admissible?
Well, I don't know. I haven't seen it. I don't know what it looks like, but it is a document that would show whether or not they do have an agreement or not. You know, Mrs. Samantha, we haven't been able to depose her again. And so she did not talk about that agreement. Only Mr. Smith did. So we're not in a position to develop that right now. That's why we're seeking this information.
Okay, Mr. Garcia, you wanted to say something about phone records?
Well, about the phone records, sure, Judge. I mean, like I did say in my motion, if there is a phone call last week, it's going to come out. If I produce it as Mrs. Torres has directed. So from the end of February 2017, all up through 2017, right? It's going to be another 10 months. 2018, 2019, it's 2.5, it's almost 3 years. 2020. So that's 4 years. And if there's a phone call, and I don't know if you saw the motion that's a lot of documents. Now they can go through all that, and I don't know that they will, but if they will, let's walk through that. Let's assume that they find a phone call from my client's uncle, the decedent's brother. What probative value is that going to have? It's her uncle. Let's say she gets a phone call from Clay Hoblet. Let's say she gets a phone call from Joe Shigerick. Those are people who, when they were deposed, said they've never communicated with her. Well, let's say that since then they've exchanged a phone call. What probative value is that going to have on his testamentary capacity? What impeachment value is it going to have? Nobody's going to get caught in a lie. And if Mr. Smith admitted to an agreement, and let's assume there is a theory in which it could be admissible in trial to determine the testamentary capacity or under influence at issue, well, then they have it. They have it, and they can go forward on his deposition. What good is a text message going to do? That's going to be redundant. And then you would have repetitious evidence. So that's why I say, Judge, I never objected to them conducting third-party discovery. As a matter of fact, they did subpoena Mr. Smith's phone records. They deposed Mr. Smith. They've been able to depose Joe Shigerick, Bill Barfield, all the people that were late designated. I never objected to them deposing Clay Hoblet or Joe Shigerick's wife, Kathy. Those can still go forward. I don't know what the phone records, and I don't think Ms. Torres has really put forth a meritorious argument about why the phone records and a call to and from a family member is going to be probative evidence in this case.
Your Honor, the phone was deleted.
Is that
I'm
is that your
sorry.
statement, Mr. Garcia?
Yes, Judge, I'm sorry, that concludes my statement.
I'm going to give you the last word, Mr. Torres, so
Thank you.
finish up
Thank
your
you, Your
presentation.
Your Honor, the phone was deleted by the plaintiff's family member, her child. Okay, we're stuck with that. Apparently there's nothing there that we can recover. So all we have are phone statements, and everything after that, she had a new phone. So if he doesn't want to give us billing records that show calls in and out and text messages in and out, well, the good news is she has a new phone after that phone was deleted. She should have all her text messages, and he can review those and give us those. If Your Honor wants to limit the calls going in and out from anybody not on his trial list, I'm fine with that. If he wants to say, if Your Honor wants to say you don't need to give them phone calls going in and out up to today, to the present, then I want to make sure that we do get those text messages, if there are text messages. If they're not, then there are none. But Your Honor, this is a very simple case of a discovery dispute. There has been no evidence of undue burden. He's saying it's 3 years, 4 years is too much. We cannot get the text messages from the phone that's been deleted. All we have left are billing statements for that time period. Everything after that time period, there should be a text message unless it's been deleted. And we've already had that discussion at the last hearing about those deleted text messages. So they should be there. Emails, if they exist, they exist. If they don't, they don't. If they're relevant to the 4 areas that we're requesting, the decedent, the estate, our client, or her claims and causes of action, then they're relevant. I'm not asking for casserole recipes. I'm not asking for how the mother's doing in her health. I just want to know about those 4 areas. So the conversations should be pretty limited. And if there's a lot of conversations about that, then it's possible it's not relevant and admissible at trial. But if he would like, he could submit them to you for an in-camera inspection, and you can decide if it needs to come to us. But I just don't, there's a lot of hesitancy to give us records because Mr. Garcia feels it's an undue burden or it's not relevant. But because she knows nothing, she knows her entire lawsuit is based on what other people have told her. We need to know what their motivations are. We need to know what they've said in the past and versus today, and what they're going to say at trial. So, Your Honor, I would just ask that you review this motion again. Mr. Garcia has already waived his objection as to 196.4. And really, you have to decide, as to relevance over breadth, and in some cases, at least as to RFP 23, whether it's vague and whether it's not burden.
So does the last paragraph in your proposed order discusses a privilege log? There's no asserted privileges that are being made at this time.
He's asserted only attorney-client privilege as to
exclude in the last paragraph.
yes.
So, or did you get a copy of the proposed order, Mr. Garcia?
I saw that a copy was sent to you, Judge, and I admit I have not looked at it.
Did you get a copy?
I did, Judge, yes.
Well, let me, if you don't, well, I'm wondering if, do you have any objection to that proposed language that deals with asserted privileges? It reads as follows: it is further ordered that on or before a certain date, plaintiff is to provide a privilege log identifying any communications other than those with her current counsel that are being withheld on privilege grounds. In other words, if you're not asserting any privilege on any other document other than communications between your client and yourself,
Right.
then you produce a log.
Yes, right. No, I have no problem with that. And as a matter, I'll state on the record today, the only communications that I am, that privilege applies to are those with me directly. So there would be no privilege log, and I will even, I guess, waive the privilege at this point. I mean, if it's going to be such an issue, the only reason I
Well,
started
I'm just wondering if you have any objection to my ordering you to provide a privilege log for any document that you are asserting a privilege to other than attorney-client. I'm not asking you to waive anything. Do you have any objection to that paragraph as being included? So I have overbreadth and relevant on text and on text messages and emails. Is that what we're down to?
text messages, emails, and then the phone records, Judge.
Sorry, phone records. That weekly case, the Corpus Christi case, you said you included it in some pleading in your motion, or?
It's in my motion to compel, Your Honor, in paragraph 22 through 24. You can find it referenced in those paragraphs. And just for the record, plaintiff did supplement her interrogatories, so that is no longer an issue and not mentioned in the order.
Okay, paragraph 24 has the In re State Farm Lloyd's. Oh, their weekly case. Okay, all right. Mr. Stodas, you're going to have the final word. Have I heard everything that you have to say about this?
I don't want to repeat myself, Your Honor. I think you've heard enough, and I think you have enough to decide these matters.
Okay, I have your proposed order. If you want to favor the court with a proposed order, Mr. Garcia, you're welcome to send it to me. If not, I'll just, I'm going to take this under advisement and I'll issue a ruling as soon as I can.
Would it be okay if I get that order to you by tomorrow morning?
Sure, I'm not going to do it. Yes,
Okay.
it's okay.
And,
Okay.
Your Honor, you'll be considering the motion to exclude to be decided sometime after the 10 days, after the next 10 days?
Yeah.
Okay.
If I feel comfortable in making a ruling on submission after I have a response from Mr. Garcia, I'll issue the ruling, and not I'll set it for hearing.
So I will file my response on or before August 16th.
10 days, correct.
And will we have another hearing? Will we need to have a hearing to talk about the trial date, or will you just issue an order, Your Honor?
I'll probably just issue an order, but I will honor your assertions that neither one is really easily available before February 2022. That really works for me too, in terms of I want space between the health issues and so
No,
it makes sense to me.
I agree.
If there's nothing else, we'll be in recess. Mrs. Gutierrez, thank you for helping us. I appreciate it.
Thank you, Your Honor.
Hernandez,
Thank
I
you.
like your background. He's on mute. Okay. All right, y'all have a nice day.
Thank you,
Thank you,
Judge.
sir.